Today, the Department of Justice is suing the state of Georgia. Our complaint alleges that recent changes to Georgia's election laws were enacted with the purpose of denying or abridging the right of black Georgians to vote on account of their race or color in violation of Section 2 of the Voting Rights Act. Where we believe the civil rights of Americans have been violated, we will not hesitate to act.
The Biden administration delivering on its promise to step up in the fight against voter suppression laws spreading like wildfire in state legislatures all across this country. The DOJ jumping into the fray in Georgia, suing that state for its voting restrictions, described even by Republicans there as predicated on the big lie and clearly designed to erect obstacles for Democratic-leaning voters and communities of color. Unfortunately, it could simply represent the beginning of the beginning for the Justice Department's efforts on this front. The Georgia law passed in March, just months after the Capitol insurrection, and the ex-president's attempt to overturn the election was the tip of the spear for the wave of voting restriction laws passed by GOP-led state legislatures and inspired by the law of voter fraud, making that state an early flashpoint in what has now turned into an all-out war for the very future of our democracy. The bill, which curbs the use of absentee ballots and ballot drop boxes, lets the Republican-dominated state legislature seize control of election boards. It even makes it a crime to hand out food and water to people waiting in line to vote. It was referred to by the New York Times in a comprehensive analysis as, quote, a breathtaking assertion of partisan power in elections, making absentee voting harder and creating restrictions and complications in the wake of narrow losses to Democrats. Assistant U.S. Attorney General Kristen Clarke today calling the law an attack on the voting rights of people of color.
After a historic election that saw record voter turnout across the state, particularly for absentee voting, which black voters are now more likely to use than white voters. Our complaint challenges several provisions of SB 202 on the grounds that they were adopted with the intent to deny or abridge black citizens equal access to the political process.
Joining our conversation, New York Times Justice Department reporter Katie Benner joins us. Also joining us, Jason Johnson, politics and journalism professor at Morgan State University and a contributor to the GRIO. Katie Benner, take us through, we'll take us through today's announcement first, and then we'll talk about what comes next.
Sure. So what the Justice Department did today is it said, we are going to fight what happened in Georgia. It was a really big deal for the Biden administration because this is really the first time it has moved in an enforcement manner to deliver on its promise to push back on restrictive voter laws. And what the Justice Department did, interestingly, in its lawsuit, is said that Georgia had the intent of discriminating against black voters. Now, under the Voting Rights Act, the Justice Department doesn't actually have to prove Georgia's intent. It could argue that the law in its totality has the effect of discriminating, which would be good enough under the statute to push back on what happened in Georgia. However, the Justice Department is being more aggressive. It's going one step further and saying that lawmakers actually had the intent of disenfranchising black voters.
So my question about what happens next is rooted in the fact that your home colleague has reported that the Texas law is even more egregious in that category. Does the department plan to sue Texas next?
So this is one of the things that was asked at the press conference, and the Attorney General just said they were going to look at the facts in the law, and that when they see that states have violated the Voting Rights Act, they will certainly act. He's basically, again, signaling that states should be wary, should be mindful of the fact that the Justice Department is watching them and is not afraid to take action. But also keep in mind, these lawsuits take an extraordinarily long time to wend their way through the courts. Yeah. Certainly, no matter what the decision is, it will be appealed. And in the meantime, there will be elections that are held under these sorts of restrictive voting laws. And so this is also a real test of whether or not the Justice Department's enforcement action will be taken as a signal to states to sort of hem in their impulses to pass more restrictive legislation, or if it will be taken as a challenge. We saw, Georgia's Governor Brian Kemp come out and say, listen, other Republican states, the Justice Department is coming for you. He certainly couched it as a rallying cry to be even more aggressive when it comes to passing these kinds of restrictive voter laws.
Jason, I want to pick up on Katie's point. This is just the audacity, I guess, of being a Republican in this era. So this is Kemp's statement. This lawsuit, the Justice Department's lawsuit against them, is born out of the lies and misinformation. I'm going to stop right there. He talks about lies and misinformation. His state's lieutenant governor said the same thing about their voter suppression law. I mean, they have perfected the politics of projection.
Not only that, but remember, like the Secretary of State, his whole family was being threatened. People were threatening Brian Kemp. If we look at this in a purely cynical political way, right? This is an amazing thing for Brian Kemp, because Brian Kemp gets to run to all the Trumpers and say, see, Biden's after me. I'm a hero, blah, blah, blah. This saves him because, quite frankly, I don't think his chance. I was putting his chances at 50-50 of getting his party's nomination for next year. They are afraid of Brian Kemp versus Stacey Abrams, too. So having Biden as the enemy, that may actually help Brian Kemp. Here's the other thing that comes into play. It's also good strategy on the part of the Biden administration, because this is, I think there's a reason that you would go after Georgia instead of Texas, because Democrats won Georgia in 2020, because Raphael Warnock is up for re-election in 2022. If there's a place that they want to marshal their resources over the next 18 months, it is the state of Georgia, because they don't want to lose that seat. So I think this is a great move, slow hand clap for the Department of Justice and Merrick Garland. And I hope it's the beginning, because I don't think this is going to intimidate any states from passing these laws. But I do think it's a sign that they're coming to get you if you're trying to keep black folks from voting.
Let me just follow up and say that Texas hasn't passed its law yet, and that may be something that keeps them from filing a suit there. The Democrats heroically walked out, depriving the Republicans of a quorum, and Governor Abbott has said he'll call them back. But Mark Elias, Democratic election lawyer, has given the Justice Department a list, Jason, to your point of who else to sue. He tweets this: I'm thrilled that DOJ is suing Georgia. If DOJ is looking for other state laws to challenge, here's a list of where my team is suing: Arkansas, Florida, Georgia, Iowa, Kansas, and Montana. And my question is this. This is from the complaint, Jason. They write, a barrage of lawsuits alleging voter fraud were brought, and although nearly all the lawsuits were dropped, dismissed, or settled at a court, the issues raised in them became blueprints for the proposed election changes in the Georgia General Assembly's session. Some of the same attorneys involved in the lawsuits testified at a state legislative committee hearing about election legislation that would eventually find its way into SB 202. In particular, during a state Senate Judiciary Subcommittee hearing in early December, lawyers replayed misleading video footage of mostly black Fulton County election workers tabulating ballots, alleging that the video contained evidence of voter fraud, although these allegations had already been debunked by the Secretary of State's office. So the Justice Department works, as Katie said, slowly, to everyone's chagrin, very, very opaquely. But they've been watching as courts have thrown out bogus contention after bogus contention, and they seem to be trying to bring some of that to bear in this lawsuit. Do you think that'll work, Jason?
Nicole, I hope it does. My concern is this. Depending on what judge you run into, we've seen examples where there are rulings that say, hey, look, you're going to throw out this law because it's discriminatory to black people. But we've also seen judges rule that, look, there is nothing wrong with creating policy that makes it harder for your opponent party to get their voters out, as long as we don't think that's specifically about race. And that's the way that conservative judges have often tried to slice this pie. They're like, oh, no, this isn't about black people. It's about Democratic voters, and they can do that. So I hope that the Justice Department can draw a straight line from the big lie to the insurrection to Raffensperger through Kemp, through all of this, through Donald Trump basically calling and threatening, through Lindsey Graham calling and getting involved in this process. I hope they can show that the motivation behind these laws is dishonest and about suppressing the vote. But it depends on what judge they end up with and how far up the legal system this ends up going in the next 18 months.